Westchester requests that all potential confusion be eliminated by a direction to the clerk's office that the caption be amended to remove from it the names of those individuals who have been dismissed and the names of the remaining defendants be reworded such that the case may be called as Glendora versus UA Columbia Cablevision of Westchester Incorporated, doing business as TCI Cable of Westchester, Illinois. You don't agree? You don't agree with that?
Oh, no. Violently and vehemently, I do not.
Okay, then the defendant's application is denied. The caption will remain as the clerk has it.
Thank you.
Number 31. From the plaintiff. Has to do with contacting parties to the action. Has to do with the designation of post office boxes by individual parties. The plaintiff claims that
Oh, I'm contacting non-defendants, non-parties.
well, I have to tell you this.
I'm sorry.
The plaintiff says this is already a free speech case. The answering brief, letter brief from the defendants indicated that their position is the plaintiff is continuing to harass these individuals. They say that Malone and Magnus and Telecommunications Incorporated are not parties to this action. As far as non-parties are concerned, no decision is required from either side, or by either side, from me, on number 31. Individuals who are not parties are not under the control of the court unless they're subpoenaed. If they don't wish to speak to the plaintiff, they don't have to. It's entirely up to them. If in their view the plaintiff is harassing them, then they have options under the civil and criminal laws to deal with harassment. Numbers 32 through 38. I've read these. There's nothing in any of these that requires anything from me. This appears to be the plaintiff's views of what's happened previously. I don't see anything in any of these that requires any ruling from the court. Number 39. It's a copy of a June 21st letter from Mr. Wiles to me, and it's notes to the lawyer by the plaintiff. It doesn't raise any issues. It's confirmed me that it comes within the scope of my reference order. Number 3. Appears to be something signed by Franklyn, who is not a party. Apparently these are his recollections or his impressions of what happened. In conferences, nothing in here that requires any ruling by me. Number 41. Also something from Mr. Buell, but doesn't raise any issue that I need to consider this because Mr. Buell is not a party. Number 42 through 44. Appear to be, again, impressions or notes of Franklin Buell, who was not a party. They have nothing to do with anything that I need to do on this case. Number 45 through 49.
Well, that was quite a conference, wasn't it? And we will go over it, you and I. I'm going to write the paper on it and make note of all of the points won and the points lost. Although there weren't many lost, were there? Anyways, Judge Fox left the bench. Ron Pura stood and asked him if he could speak. And Judge Fox said no, he wouldn't listen to anybody outside of the case. And then Ron Pura says at this next August the 8th, he said, I'd like to know if I could videotape it. And Judge Fox says, no videotaping. And so Judge Fox went out into the chamber and shut the door. He opened the door again and stuck his head out. And he said, the rules of the Federal Judicial Conference say no videotaping. And he says, there are some judges in the Southern District who allow it. He says, I do not. And then Ron Pura says, well, may I audio tape it? And Judge Fox says, well, the deputy clerk audio tapes it. So that was the end of the conference. And then I went out in the hall. First of all, I talked to Mr. Poole, and he was in a rush. And so when he went down the elevator, I sat down and I talked to Elizabeth Holm. And then after I finished talking to Elizabeth, I went over and I talked to Ron. These people were all wonderful to witness. Oh, what a difference it makes. What a difference it makes. Do not go to court without witnesses. And there was a case and then when Mr. Pure went, I talked to Mr. Sussman. There was a case at 8:45, and the other side didn't show up, and Judge Fox was furious. And so that was over at 9:05, and then he started to go into mine, and my people hadn't arrived yet. And I said, Judge Fox, Lyle's wanting to start. And I says, no, Judge Fox, I'd like to stick with the appointed time because I have 4 witnesses. He says, witnesses? I'm not taking testimony from anybody. I says, no, these are witnesses who are hearing the hearing. He says, oh, sure. He says, I'm going to start at 9:15. Okay. Now the next piece of business was Wednesday morning, and this is the conference with Mr. Schimmel. Okay, and that's on audio tape, and I'll play that for you.
Bye-bye. Morning, Nick. What is time? Okay, I'll call Mr. Schimmel. Okay? Are you close to the phone? I am. Right now you're good. Okay. Okay, before you were. Okay, we'll call Brian Substerman, see if he can listen in on this. Yes.
B6.
You want the court to reconsider its prior ruling as to the opportunity of an argument. Right, if the moment and argument as to have aggressive and no 6 months notice for discontinuance of service. Right, those are okay, so go back on Monday morning and I will tell you whether there will be a re-argument of this purchase information of the court's ruling.
She has no idea what he's talking about.
HCI is the corporation that operated the Westchester franchise is owned, and operated by a corporation which is holding or regulating U.S. Columbia Cable Division of Westchester, DPA, Cable Westchester, and I'm trying to consistently refer to that subsidiary corporation, DPI Westchester. Object. Right.
That you can understand.
Ultimate decision maker too. So you're saying that Mr. Marshall is the director and an officer of the subsidiary that owns and controls the Westchester franchise? Is that what you're saying? Well, yeah, I'm not familiar with the case. I need to understand what you're saying. I know the sole basis on which this kind of refused to listen. Mr. Chanel, I can't let this go on. I need to understand what Mr. Long is saying. Let me ask the question again because I want to know whether I understood it correctly or not. Mr. Marshall is a director of a subsidiary of CCI. Is that correct? This subsidiary of CCI is controlling the franchise that operates in Westchester. Is that what you're saying? Yes. I have the subsidiary of the party here. This party. Okay. The subsidiary is not a party. We went to dismiss them originally, and that aspect of the motion was not without prejudice to its renewal. What I'm asking you here is to move the motion to make it now that without dismissing the statement. The discovery is not complete. Okay, all right. Just a second. I get Mr. Well's argument, and I get your argument. All right. Well, my argument is that we've actually gone through the discovery that Judge Connor was anticipating, and now we want to make the motion again to take him out again. Amen. Counsel. Okay, you ready for me, Mr. Small? Yeah, go ahead, Senator. All right, this is all wrong. He brought this up before Judge Fox yesterday, and Judge Fox denied it. And it's all settled. We're not getting anywhere in this case. We're going backwards, we're not going frontwards. And he is delaying this whole case. And he's not going to get away with dismissing Marshall. I have had enough of having my other defendants dismissed. Now, and I have a motion before Judge Fox on that. And Judge Fox is because my understanding is that this case is referred for all pretrial purposes to Judge Fox. Why is it that you're applying to this court for you to file a motion then? Okay. The reason is,
Yeah, try and make up a reason.
with Judge Fox yesterday, and I believe the last time was last week, I think. Before. June 18th, Judge Fox said, he said, the matter is referred to me for discovery purposes. And whatever else Judge Raycroft wants me to do. And specifically, he said, I understand now that I'm to report, to make report recommendation on the motion to dismiss, so I'm going to do that. And
17th, 1996, Wednesday. What a mess these courts are. We have 3 jokes for you. What's the difference between a train and a teacher? Train and a teacher. A teacher says don't chew and a train says chew, chew, chew. And the golfer said to the caddy, "Caddy, why do you keep looking at your watch?" And the caddy says, "This isn't a watch, sir, it's a compass." Annette said, "I knew this was going to be a good day when I went to the supermarket and I got a grocery cart and all the wheels were going in the same direction." Remember the Bible passage? For we all must stand judgment before God. This is the chat with Glendora. God bless you. It's too bad that we've been deprived of courts. Take care. This is my Long Island address, 1395 Huntington Avenue. Excuse me, 1395 New York Avenue, Huntington, New York, 11764. And the telephone number is 516-425-0304. This is Route 110 South, and this is Route 110 North. And this is Franklin, and this is a 1980 Lincoln with 216,000 miles. And today is July the 19th, 1996, Friday. The time is 3:30 p. Fade. Test with the 600 watt light. That's pretty clear. That's a dark picture. To watch my feet. That is not a good picture. Okay, now let's remember the order that we did this in. PC1 Canon copier, Magnavox VHS, Smith Corona typewriter. Okay, now we're going to fade out. Now we're going to take off the 600 watt light and put on the new 150 watt light and see if it's any different. Cat. Okay, fade out. Phone. This new microphone we bought at Amityville in Long Island on July 19th, 1996. We were out there 10.5 hours times 2 people. That's 21 hours. And this new microphone costs $32. And we bought it at Burgers. And so this is a test. See if you like it. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And Linda Greco will be very happy if it works, because my poor other microphone came from Radio Shack. It lasted 6 years, and that's pretty good. And but a wire has broken, and you get the crackle, and it's ruined quite a few programs the last few weeks. So fade out. Well, I don't know if there's any difference between the lapel microphone, the lavalier, the lapel, than it is between the, so 11, 12, 13, 14, 15, 16, 17, 18, 19, 20 is with the lapel. And now we're going to take out the lapel and go on to the microphone that's attached to the camera. 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. Now we'll plug in the lapel microphone again. 1, 2, 3, 4, 5. Maybe I was too close with the lapel. I was too close to it, so I'm going to unravel the cord. It's just like yarn. It won't cooperate. I'm trying to go over to the other side of the room. I'm trying to unravel this cord. Thank you. Just like yarn. You know, it gets all twisted up. I'm about...
As you go, it'll all clear away.
It'll all get tangled. Okay, now I'm about 7 feet away. It's a nice long cord. Ooh. Okay, now I'm about 12 feet away from the camera. So this is test 31, 32, 33, 34, 35, 36, 37, 38, 39, 40. I certainly hope it works, because I don't want to wind up that cord again. So fade to black. Okay, so I guess it works. I guess it works very well. It's nice to buy new things, but it just takes so long to check them all out and see if they're going to work. Okay, so I guess we'll keep that microphone. Today is July the 20th, 1996. It's 9:39 a.m. and it is Saturday. And that humid and hot weather where we had humid humans, that all disappeared. We had a thunderstorm and then a nice breeze came in. It's pretty cool. What's on there? The noise and the coffee drink. I don't think we can get a white balance. Well, maybe. Here it is. This is Cablevision, Hicksville, New South Road. The latest report on Thomas Garger is that he will call Glendora before the end of the week about editing. You can see the Cablevision awning over there. And those are the offices of Thomas Garger and Diane Bennett. And the time is 2 p.m. and the date is July the 23rd, 1996, Anno Domini, and I can't stand out here in the rain with the camera any longer. Every time we come to Long Island, it's raining. And there's the trusty Lincoln. Fade. Okay. 1,374 tortious acts since April, Easter 1993, and 4,154 pages, 32 volumes, and 3 file drawers full of bad record these people, these neighbors have made for themselves. 186 TV reports, a half an hour each, all bad, and 3 years, 3 months. This is exhibit 114, and it's been 244 mailings. The Walsh's will be moving next week. That's 2 down and 1 to go. The Larkins have gone. Al Pucci's Theo and Neil went out with great big suitcases and backpacks with their father Ferdinand, and so that's a good thing. The roofers illegally dumped in the woods next door. I was busy writing a legal paper. I didn't catch him. If I had, I would have called the police, and the police would have issued a summons. And I think one more thing, just join Neighbors and Tenants, New York Neighbors and Tenants Association. They're in Manhattan. Join them. Because remember, the millionaires have $1 million lobby against you up in Albany. Welcome to a chat with Glendora. This is the Long Island edition. How you doing? I'm going to tell you your 3 jokes. The unemployment statistics show that 3.5 million Americans are idle, and most of those are working for the government. And what was your major in college? Mary Ann asked Lewis. And Lewis said, English grammar, communication skills, and advanced oratory. Mary Ann said, really? And Lewis says, yeah. Those are working for the government. And what was your major in college? Mary Ann asked Lewis. And Lewis said, English grammar, communication skills, and advanced oratory. Mary Ann said, really? And Lewis says, yeah. Fred said, we now know why they are called grandchildren. Why? It's grand to see them come, and it's grand to see them go. I have a new light, which I bought at Burger Brothers down in Amityville. Do you like it? It's only 150 watts. Since 1987, I've been using 600 watts. Do you think it's good enough, this new light? Of course, the lower the light, the better I look. And also, I have a new microphone. Do you like that? I bought that too at Burger Brothers in Amityville. Now, must tell you that Americans for Legal Reform, they are having a party, and it's this Saturday, July the 27th, and it's at the Old Beach Inn, and it goes from 1 to 4 in the afternoon. It's $10 donation, and it's $5 for children. Legal Eagles, or those who wish they could reform the legal system. We're talking about lawyers. Learn while helping others, assist others, getting started, be part of the solution and not part of the problem. Bring your family, join us for drinks, good companionship and fun. There will be no July or August meeting this year of the Americans for Legal Reform. The next rally is July 31st, 1996 at the Nassau County Supreme Court, Mineola. And the next meeting is September 24th, and the next rally is September 25th. And be sure to watch Americans for Legal Reform on Channel 25. The last one was July 23rd at 10 p.m. Don't forget the Florida Convention, August the 2nd, 3rd, and 4th. And for further information, call 516-421-63900. That's going to be great because the National Congress for Lawyers Reform is in one motel, and next door at another motel in Orlando is the American Bar Association, so you have evil and good door to door. I have a funny cartoon to show you. It's Family Circle. They're always very funny. See, the little boy is looking at his cat in the box, and the little boy is saying, it's in a shoebox. The little boy is saying, we have a size 9 cat. I'm going to read you the statistics, give you a brief outline of what happened in 1993, Veterans Day. Charles Dolan, John Tata, William Quinn, and the rest of the people whose names you see on the TV screen took a chat with Glendora off of the TV because Glendora was reporting on the bad work of the Department of Consumer Affairs in Nassau County, that James Picken was allowing Scott Lord to operate a consumer affairs business. He now owns Forever Green. He changes his name every year, changes his address, changes his lawyer 6 or 7 times a year. And they allowed Scott Lord to operate this consumer affairs business without a consumer affairs license, not protecting the consumers of Nassau County. This was done under the full knowledge of Thomas Galata, who exchanged maybe 12 letters with me on this matter. And I was reporting this every week on my program. And under Information and Belief, I believe the politicos in Nassau County exerted pressure on Cablevision to take Glendora's program off the TV because the next 4 programs coming up were virulent in their exposure of Nassau County consumer affairs. And also the DA's office, Mr. Irace, who allowed Scott Lord to bounce a check and never prosecuted it and gave all kinds of excuses why not instead of doing the job. The great public defender. When the Cablevision Systems Corporation, the names that you see on the screen, did take Glendora's program off the TV, they did it in their usual cable TV operator ignorance of the law and their arrogance thereof. And they violated statute 47, United States Code 531E, which says no cable operator shall exercise editorial control over public use of channel. So that is the synopsis, and I sued them and I won, and the New York Supreme Court, Donald N. Silverman, said, put Glendora's program back on the TV. She has a statutory right to be on TV. It is a statute of Congress. And so they had to put me back on TV, and that was in September of 1994. And I've been on ever since. They are, of course, trying to get me off again. The same crooked politicians who took me off, who exercised pressure, I believe, on Cablevision to take me off the first time, are trying to get me off again by exerting pressure on the Appellate Division, 2nd Department, to tell Judge Silverman to reconsider his decision. So they're trying to get me off again, and their latest ploy was that Glendora is not a member of the public within Nassau County. Well, she is, okay? And you see the address on the screen, 1395 New York Avenue, Huntington Station, New York, 11746, Route 10, and the telephone number is 516-425-0304. So to pick up on what this has cost me, 3,009 and a quarter hours of my life over the past 2 years, 7 months, and you multiply each hour by $250 an hour, which is what this lawyers rip the public off for. Lawyers are as much as a monopoly as cable TV operators are. So you multiply 3,009 1 and a quarter hours by $250, and you get $752,312.50 worth of lawyers' labor that we have done to fight these crooks. We have spent $6,247.25 in postage and printing and rip-off court stenographers' fee. Another evil in the courts. Not only do you have bad judges and lying lawyers, but you have crooked stenographers charging you $4 a page. We have to get rid of all that. We have to get rid of court stenographers. We should be allowed to go into a court and audio tape the proceeding or videotape it and get our record that way and not cost us a cent. 43 volumes of bad record, 4 file drawers, 12,900 pages of bad record, 267 TV reports, all bad, a half an hour each. And as I said, this is 2 years, 7 months, and 295 mailings. And I was reading you a week ago. Let me go back here. I should have been reading you the stats for the week that closed July 21st, last Sunday. 3,045 hours, $761,250 worth of hard legal labor, $6,286.32 print, post, and rip-off stenographer fees, 43 volumes of bad record, 4 file drawers, 12,944 pages of bad record, 269 TV reports, a half an hour each, all bad, in 2 years, 7 months, and 295 mailings. Thursday, the last time I saw you, we videotaped and edited all day. Friday, we spent in Long Island all day. I believe the first stop was Hicksville, where Thomas Gardner refused to speak to me and where Diane Bennett refused to speak to me. And they are the public access coordinators, and this cannot go on. It is suicide. Let me tell you, it is suicide. I think they're taking their direction from that crooked Joseph Asnara, who lied all during the deposition that Glendora took of him for 3 hours, and which cost Glendora something like $450. As rip-off court stenographer fees. And from Robert Callaghy, who is Cablevision's paid a liar for hire. That's what you call a lawyer. An attorney is a liar for hire. And so I believe the direction is coming from them. But that is suicide. And I wrote Thomas Gardner a letter, and I told him that. And the letter begins with, could you please set up 3 hours editing time for Glendora with Patrick at the address above, my address being 1395 New York Avenue. Glendora's editing requirements is the same as we discussed at great length in the fourth quarter of 1993. Monday or Tuesday morning or afternoon are the most convenient days for Glendora. Would you kindly set a date and time and notify Glendora at 516-425-0304 or 516-385-3341. Thank you. You have been ordered by the United States Court of Appeals to send everything to 1395 New York Avenue, Route 110, Huntington Station, New York, 11746. I am the appellant. You are the appellees. Please execute. A true copy of the court's order is enclosed. Your refusing to speak to Glendora is not acceptable. You are running public access temporarily. I am a public access producer. You have to speak to me no matter who tells you not, Mr. Asnara or Mr. Callaghy. My free speech is violated, so is yours. You can be sued again for big dollars, both for violating my federal, statutory, and constitutional rights and for reckless disregard of my state public access rights. You can, if you wish, designate somebody to speak to me. I've said what I meant, and I meant what I said. Now that I have a Long Island address, I will activate my state legislators, Conti and Lack, and also Ackerman in the Congress, and certainly my United States Senator and Senators DeMonto and Monahan. There's a carbon copy of this to Dolan and all other appellees and to Robert Callaghy, and that was sent out on July the 15th. That was Monday. Yes, yours in truth, Glendora, a chat with Glendora. The latest on that is that I went to Long Island on Tuesday, July the 23rd. I said I came to pick up a tape, and I wanted to speak to somebody about editing. and Rich in security went out behind their closed doors, their locked and closed doors. They're naturally afraid of everybody because they've done such a bad deal on the public. And Rich came back with the word that Tom will call Glendora about editing by the end of the week. The end of the week is pretty close. It's Thursday now, and we haven't heard. I wrote a letter brief to Donald N. Silverman, Justice of the Supreme Court, State of New York, Westchester County, the man who put Glendora back on TV after Cablevision broke all the laws and took Glendora off of TV. And I sent to Justice Silverman Glendora's telephone bill. And it was huge. It was $145. It is paid. And now I have to find it to show it to you. I guess it didn't get bound into the book because it went to Justice Silverman on Monday. Yeah. And it says, enclosed is Glendora telephone bill showing she is a member of the public within in Long Island in Huntington Station within the franchise area of Cablevision Channel 25, where you put her back on TV July 14th, 1994. That's when he gave the oral order. When he gave the written order, it was July 29th, and I went back on TV on September 4th, 1994. Also enclosed are library programs that she can go to just 2 miles north of 1395 New York Avenue. They are nice library programs. Americans for Legal Reform is speaking there, or did speak there Thursday, July the 25th at 7:30 p.m. I edit up until 7:30 p.m. on Thursday, so I couldn't go edit in White Plains. But I would love to have gone to that. And then they had a program on swinging into a new golf program for persons with disabilities. And they had a program on the American flag. And they had a book discussion group, the Huntington Public Library. Wonderful, wonderful place. Go there, folks. Oh, okay, back to Judge Silverman's letter. Mr. Callaghy has obeyed the court order to serve all papers at 1395 New York Avenue. She asked for a similar order on him from you, Judge Silverman, from your court. Compel Mr. Callaghy to serve all papers on Glendora at her designated Long Island address. Mr. Callaghy deviously fails to mention the papers served on him by Glendora with a Huntington postmark. Mr. Callaghy's affidavits of service on Glendora and Huntington are enclosed. Also enclosed is defiance of the court order to return Glendora's videotapes to her Huntington address. That's a very poor letter from Thomas Gardner to Glendora. It's dated way back in June 8th, and I received it on July 15th. That's a month and a week later. It has no return address, so I won't be able to refuse it. And it's a very dumb letter saying that all Glendora's videotapes are going to be returned to her in White Plains in opposition to the court order that all videotapes be returned to Glendora at Huntington Station. Glendora applies to this court that Thomas Gardner and Diane Bennett cease and desist their refusal to speak to Glendora or to see Glendora the last 5 times that she's gone to Hicksville when Glendora picks up and leaves her videotapes to Cablecast. Glendora has a right to edit her program at Hicksville, and Gardner and Bennett refuse to talk to Glendora about it. Glendora asks this court for an order that these two fulfill their public access duty toward Glendora, both state and federal, and schedule the 3 hours editing time she needs every week. She is, after all, on the system, and Mr. Gardner told Glendora November the 11th, 1993, that if she came back on the system, she could edit there. This is on audio tape and on transcript in your chamber's file. Robert Callaghy still has not paid the $95 for that audio tape he requested. This is a Park Avenue lawyer, and this is Cablevision, okay. I think they're $2.5 billion, aren't they? Isn't that their annual revenue? And Robert Callaghy has defied 5 judge orders by Judge Bryant to do so. These are the kind of lawyers Cablevision pays dividends to, nor has Callaghy produced the insurance agreement that both Judge Fox and Judge Bryant ordered him to do. You cannot find anybody more violative of the law than Cablevision, Dolan, Tata, and Quinn. And the other names that you see there. Here is the NYNEX telephone bill. $145 for the installation. And I must warn you, Chrissy Crisaro, you are violating a law that's aggravated harassment to use an electronic instrument the way you are using it. And your address and your number will be found. And if you keep this up, you're going to, the police are going to come and you're going to have a record. Now, at 16 years old, if you want a record, a police record, that's what you're going to get. So I would lay off if I were you. You know, calling 24 times a day, 27 times the next day, 23 times the day before. That. You got to be a special kind of a stupid to do that. Okay. Oh, I started to tell you what we did in Long Island on Friday, July the 19th. So we went to Hicksville. And then we went to Staples. We spent over $300 right around there. Plainview, Hicksville, Huntington, Amityville, Massapequa, and let's see, where'd we go from Staples? We went up to the post office on there in Hicksville. It's a nice post office. And then we went east on, I guess we took the northern state. We went to the post office in Melville. We went to New York Avenue. We have a nice place there. Nice desk and telephone answering machine, and sofas, and it's a pretty yard. And it's all fixed up very, very nicely. It's a nice place. And then we went north to the Huntington Library, and then we went south to Amityville to Berger Brothers and bought this new microphone. And then we bought this new light. And then we went over to the Wiz. The Wiz is no good as far as an AC adapter for a telephone answering machine. And they're no good on microphones either, or on video lights. And so then we went to Radio Shack and we bought an AC adapter. It's 13 volts, but it won't work because I need 14 volts. I have a Gold Star answering machine. And then rain. And then we went up to Sunrise Highway and we went over the southern state until we got to the Wantagh and to the northern state and to the Fog's Neck Bridge and 295, 495, I-95 and up the Hutchison River Parkway to White Plains. It was a nice day, but we spent too much money, almost $400. And then I wrote this letter to Judge Silverman on Saturday. It was submitted on the first of the week. Then Tuesday, we went back to Long Island. And what was the first stop on Tuesday? Mineola. I went to see Judge DePaulo. He was my one shining ray of a judge who was a human being, or almost human. And he entirely let me down. Entirely let me down. I have no money. It's a known fact that I have no money. I have no money because of lawbreakers like Cablevision, Dolan, Tata, and Quinn, who are all multimillionaires. They're breaking the law, and then I go to court and I encounter lying lawyers such as Americans for Legal Reform talk about, and I run into inept judges or judges who are not true to their oath or to their calling or to the Constitution of the United States, like Judge Andrew DePaulo. I have no money. And I don't have $500 to pay a rip-off court stenographer for minutes. And I can't appeal without him. It's a $100 traffic light, which a policeman in White Plains said I did, which I didn't do. It was malicious prosecution. And so Judge DePaulo has really let me down. And that's too bad. I thought he was a human being. But he's just like all the rest of them. So they've denied my former paupers. How can I pay $500 for court stenographer minutes for a $100 traffic light offense? So there again, court stenographers have ruined justice. Justice is for the rich. The poor don't get a chance. So I'm very, very disappointed in him. And so is Franklin. My letter to that, the jot thoughts are over there, and I haven't had a chance to write it. Okay. So, I'll try to read that to you next week. But I'm really disappointed in Judge DePaulo and the Nassau and the appellate term, 9th and 10th Judicial District. And I think that's all. This closes the Long Island edition for Chat with Glendora from July the 18th to July the 25th. It's too bad that we don't have time to tell you the jokes. But you take care. Oh, and I also got to tell you about the Board of Elections. I think we've tamed the Board of Elections. They acted the way they should. They acted legally. I'm talking about the Board of Elections of Nassau County. And we went in and we got the files. I'm pretty sure, though, that when we come in and ask for the files, we don't get them right away. And I'm pretty sure our papers are taken out of those files before we see them. We'll work on that and report to you on that. But we did get a lot of information as to the contributors to the Oyster Bay Republican Club. And they are suspect, in my mind, as to the real reason Cablevision took a Chat with Glendora off of the TV. Welcome to the Midwest. The other names that you see upon the screen, and of their lawyer, Mr. Thomas E. Waltz II. I must read you the damages. That will be down here with the logs. And as of this week, these lawbreakers, with their lying and their covering up, have cost us 746 3/4 hours, and you multiply that by $250 per hour, which is what these greedy, grubby, crooked lawyers charge the public. They're a monopoly, just as cable operators are. There's collusion there, there's antitrust. I wish I had time to bring that suit. So you take 746 and 3/4 hours, you multiply it by $250 an hour. The figure is $186,687.50 lawyers' work we have done with this law breaking by these defendants. They're lying and they're covering up. And of course, they're liar for hire, Thomas E. Waltz II. We have spent $1,666.94 for print, post, and rip-off court stenographer fees. That's another blight on the court, another disease of the courts is court stenographers. You've got to get rid of all of them. And you've got to be allowed to take your own audio tape recorder into a court and record it and make your own record, and it won't cost you a penny. Instead of $4 a page for a page that's half empty. This is the 94th mailing. These people have amassed 3,204 pages of bad records, 1.5 file drawers full, 20 volumes, and they have damaged us 48 weeks of emotional damage and mental anguish, all because Hofstadter et al. Had to break the laws and then lie and then cover up and betray their country, which is the heart of free speech. Okay, that's what they prefer to do with their lives. Now, we are reading you Glendora's cross motion to deny a motion for summary judgment, a dispositive motion, that is to dismiss her case as a summary judgment, and that was an abuse of discretion on the part of Lisa Margaret Smith, the United States Magistrate Judge, Southern District of New York. And we had read to you up to page 71. Point 108. Again, Glendora's complaint against Hofstadter et al. Cannot be dismissed unless it appears beyond doubt that the plaintiffs can prove no set of facts in support of her claim which would entitle her to relief. Cortec Industries, Conley, and Goomer. The facts are not in. Discovery was ditched on May the 31st, 1996. Another abuse of discretion by Judge Smith. This is too soon for summary judgment. Moreover, all reasonable inferences from the factual averments must be drawn in plaintiff's favor. Madonna, Falls River, and that's near Hofstadter, by the way. These the upper defendants are located in Boston. This caution against dismissal applies with even greater force where the complaint is pro se and complains of a civil rights violation. Easton versus Sundram, 947, F. 2nd, 1011, 1015, and the Second Circuit, 1991. So plaintiff has alleged facts sufficient to maintain a claim based upon violation of Title 42, United States Code 1983, the Civil Rights Law. Hofstadter et al. In restraining Glendora's speech is not simply a private choice and is subject to state action and constitutional scrutiny. Mr. Walsh alleges on his page 3 that Hofstadter et al. Are outside state action and automatically foreclose the possibility of First and Fourth Amendment rights. This is wrong, as the reasons set forth below will show. First of all, Glendora objects to this memorandum of law about all the matters Judge Smith said in open court she could not decide. November 7th, 1995, January the 5th, 1996, February the 27th, April 15th, May the 31st, Judge Smith said she could not address the claims Glendora broached to her at these conferences. That this motion for summary judgment is before J. Smith. Why is Walsh true, writing 26 pages of matters J. Smith said she could not address? What? Paid. This motion for summary judgment is about facts. There is no dispute of facts, no jury. Why is Walsh true, writing 26 pages about law? What gives here? Glendora requests sanctions for poor lawyering. Here is the first reason Hofstadter et al. Are state actors. Glendora exposed the bad record of Westchester County officials, and they put pressure on the defendants to censor her weekly public access program, and to this day it is still censored. Every other week these reports are blacked out by Hofstadter et al. Glendora's First Amendment claim is, of course, brought under Title 42 of the United States Code, Section 1983, which provides a remedy for deprivation of federal rights under color of state law. While the state action inquiry under the First and 14th Amendments and the under color of state law inquiry under Section 19893 are not identical, see Flag Brothers versus Brooks. The conduct satisfying the state action requirement also satisfies Section 1983's under color of state law requirement, Lugar versus Edmondson Oil. Private conduct may constitute state action if close scrutiny reveals that conduct to be fairly attributable to the state, Lugar versus Edmondson. Only by sifting facts and weighing circumstances can the non-obvious involvement of the state in private conduct be attributed to true significance, Burton versus Wilmington Parking Authority. And International Society for Christian Consciousness versus Air Canada. The inquiry necessarily turns on whether there is a sufficiently close nexus between the state and the private conduct so that the latter may be fairly treated as that of the state. Blum versus Yaretsky. Such nexus is established by showing that the state has compelled or significantly encouraged the private conduct at issue. Such encouragement exists for state action purposes when the state has made plain its strong preference for how private entities exercise their discretion. Skinner versus RLEA. Westchester County officials have a motive for official pressure on Hofstadter et al. They still do, and perhaps this explains the long delays, 46 weeks, that Walsh gets with his frivolous motion staying discovery and Judge Parker's inscrutable turnabout on preliminary injunction. None of it makes any sense, along with Judge Smith's ignoring Glendora's April 27, 1996 motion. Glendora has more than adequately alleged significant state encouragement, perhaps even compulsion, of defendant's censorship of her weekly series, which continues 46 weeks later, and the court must liberally read these allegations. It's very, very suspicious why this lawsuit has taken so long. Not only do I think there's public official pressure upon Hofstadter et al., but I think there might be some upon the courts. You cannot explain the irrational judgmentship that has been displayed by Parker and Smith in this case. There has to be outside pressure somewhere. There's no other logical explanation for it. A striking parallel thus exists between this case, Glendora versus Hofstadter, and Missouri Knights of the Ku Klux Klan versus Kansas City, Missouri. In Missouri Knights, the Kansas City Council had adopted a resolution authorizing the franchise cable operator to eliminate the local public access channel and to deny the Missouri Knights' request for weekly channel time to air programs espousing their racialist viewpoint. Even though censorship of that viewpoint was ultimately accomplished by the cable operator's decision not to carry the Knights' weekly programs, that censorship had been significantly encouraged by the City Council, leaving no doubt that it was fairly attributable to the state. See also Westpac audio text. Telephone companies' attempts to eliminate dial-up porn services was state action, facilitated by state deregulation designed for that effect, vacated by settlement stipulation. Similarly here, Continental's decision to censor Glendora's weekly series in Nassau County is fairly attributable to the state if, as Glendora alleges, Cablevision was significantly encouraged or compelled to do so by the county executive. So you take out Cablevision and put in Continental Cablevision. Here's the second reason Hofstadter et al. Are guilty of state action, even absent any government or official pressure to improperly restrain Glendora's speech, that is, censor Glendora's weekly public access series. Defendant's censorship is state action because public access channels are public forums. The Latin is fora, but let us anglicize. Defendant's decision remains state action because these channels are not only vital outlets for local expression in Westchester County, but also electronic public fora where regulation of expression, that is, what J. Smith has in mind with improper restraint of speech, is automatically state action subject to the constitutional scrutiny regardless of the technicalities of property ownership of public access channels. Continental thinks they own these channels. They do not. You own them. They are public channels. Plaintiff calls judicial attention again to the Denver decision last week by the United States Supreme Court. Kennedy, in his opinion, went so far as to say that these channels are a municipality's property easement. Please read the 40-page decision from the United States Supreme Court. Following is what Glendora's amicus curiae wrote that is supported by Justice Kennedy's opinion last week. While the facilities that comprise a cable system are privately owned in most communities, private cable operators do not necessarily own every channel of communication over their cable systems. You own them, the public ones. Indeed, amicus believes that every cable franchise agreement designating cable channels for public access creates a public easement in those channels. And Justice Kennedy of the United States Supreme Court said that. United States versus Becerre. That cable operators do not own public access channels is apparent from the fact that federal and state laws, which have been incorporated by reference in most cable franchise agreements, largely bar cable operators from excluding speakers from those channels. Title 47 United States Code 531E. The power to exclude has traditionally been considered one of the most treasured strands in an owner's bundle of property rights. Loretto versus Teleprompter. Cable operators' lack of power to exclude speakers from public access channels thus strongly suggests that they do not own those channels. Hence, just as most cable franchise agreements confer private easements on franchise cable operators to build and operate their privately owned cable systems on public property, those very same cable franchise agreements create public easements to use the designated public access channels over cable systems that may otherwise remain private property. Whenever speakers seek access to public property or to private property dedicated to public use, the public forum doctrine is triggered. Cornelius versus NAACP. Indeed, the Supreme Court has repeatedly applied public forum and analysis in cases where speakers have sought access to private property dedicated to public use. Members of the City Council versus taxpayers for Vincent. Property owned or controlled by the government may qualify for public forum status. United States Postal Service versus Council Greenberg. Privately owned mailboxes were part of Postal Service's non-public forum for delivery and receipt of mail. Southeastern Promotions versus Conrad. Privately owned theater leased by city had become a designated public forum for touring theatrical productions. Marsh versus Alabama. Streets and sidewalks in company-owned town were public forums. Evans versus Newton. Analogizing a recently privatized city park to the company-owned town in Marsh versus Alabama, and ruling that segregation in that park remains state action under the 14th Amendment. Prunely barred. Shopping center versus Robins. Rejecting private mall owners' due process challenge to state constitution provision allowing positioning activity in common areas but noting that property owner could adopt time, place, and manner regulations in that privately owned public forum. Decision should not be interpreted as a blanket approval for state efforts to transform privately owned commercial property into public forums. Despite the long line of Supreme Court decisions recognizing that public forum analysis applies to private property dedicated to public use, the court recently asserted that evidence of speech activities at bus and rail terminals was irrelevant to public forum analysis because such terminals traditionally have private ownership. That's Krishna. The public forum status of privately owned terminals, however, was not before the court in that case, which concerned the forum status of publicly owned airport terminals. The assertion in Krishna thus was not only an aberration from well-established principles, but also mere dictum. Robert Perry says, professor, New York University School of Law. The mere fact that public access channels are not tangible property, like streets, sidewalks, and parks, does not render public forum analysis inapposite. While the seminal public forum cases typically involve real property public forums, Hague versus CIO, more recent cases have applied public forum analysis to any particular means of communications, even if it lacks a physical status. Cornelius, Perry Education Association. Public forum analysis begins by classifying the forum in question as public or non-public in nature. Public forums may be either traditional or designated. Cornelius, Perry. Traditional public forums consist of places which, by long tradition or by government fiat, have been devoted to assembly or debate. Government fiat. They include such quintessential public forums as parks, streets, and sidewalks. Burson versus Freeman. Places which have immemorially been held in trust for use of the public, and time out of mind have been used for purposes of assembly, communicating thoughts between citizens and discussion of public questions. Perry, quoting Hague versus CIO. But the category is not limited merely to forums open for public expression. From time out of mind, it also includes forums open for public expression by government fiat and by recent convention, Taxpayers versus Vincent. Public access channels have by any measure become a vital outlet for local expression, and indeed they have. See Offer Heidi, Cable Television in the Public Interest. Cable Access, a community communications resource for nonprofits. The Participate Report, a case study of public access cable television in New York. By contrast, designated public fora consist of public property which the state has opened for use by the public as a place for expressive activity. Perry. Under these standards, the public access channels in the Ossining system, 20 towns in Westchester and Rockland, and in other systems in the Grand and Old United States are clearly both traditional and designated public forums. First, these channels have been open for public expression by government fiat and designation. That would be the Cable Act in 1984. Not only do Hofstadter et al. Make franchise agreements with each of these 20 or so communities, municipalities requiring Hofstadter et al. To make available channel capacity for public expression, but state regulators also require every franchise cable operator in the state, including Hofstadter et al., to designate channel capacity for public access. That's Title IX, New York Codes, Rules, and Regulations, 595.46. And define the term public access channel to mean a channel designated for non-commercial use by the public on a first-come, first-served, non-discriminatory basis. Second, since inception of the public access channels over the Hofstadter et al. New York system, such channels have been open for public expression, starting with Roger McLean and American Cable Systems of New York Incorporated. In short, there is, at the very least, a recent convention, if not a long tradition, of public expression on such channels. I know, I was there when it started. 1974, 3 or 2. I was there. I started when public access started. Just like I started in broadcast TV when broadcast TV started, 1949. Hofstadter et al. Are guilty of improper restraint of speech, as Judge Smith calls it. We're up to page 79. This is the next to the last page I'm going to read you this week. This whole paper goes to page 140. Given the public forum status of these public access channels, Kennedy and Perry, the regulation of expression by Hofstadter et al. On Channel 19 South is necessarily state action. As the Second Circuit ruled in Paulson versus County of Nassau, makes amply clear. Professor Perry tells about it in French. Nassau Coliseum, when members of a religious organization challenged the private company's refusal to issue them permits to distribute leaflets on Coliseum sidewalks during heavy metal concerts. This court did not even pause to consider whether the company's policy was state action, but rather implicitly assumed that it be so. Page 80. Any remaining doubt that the regulation by Hofstadter et al. Of the public access channels over its New York auctioning system, serving 20 or so municipalities, you folks up there, constitutes state action and is eliminated by state regulations which effectively declare operation and administration of public access channels to be an exclusively governmental function and delegate responsibility for such functions to cable operators only if a municipality has failed to designate a public entity to handle such responsibilities. The public access channel, this is the law, shall be operated and administered by the entity designated by the municipality, or until such designation is made by the cable television franchisee, in this case Hofstadter, provided, however, that the municipality may designate such entity at any time throughout the term of the franchise by a resolution duly adopted by the legislative body thereof. And that's from Title IX, the New York State Code, Rules and Regulations. The Hofstadter New York system, Continental Cablevision, is coming into this modus operandi, although Walsh, too, fails to include this information in his July 1st paper, which has taken me 24 hours so far to set the record straight. Hofstadter et al. Cannot transform the operation and administration of public access channels in Westchester County from a public to a private function. Evans versus Newton. And that is page 80. Next week I'll try to read you from pages 81 to 90. Isn't it outrageous that Hofstadter, DeLorme, Nair, Schleier, all of those people whose names you see upon the screen should betray America? They should betray free speech. They should betray public forum. They should betray first come, first served. They should betray and commit improper restraint of speech. Isn't it terrible that they should be traitors to the United States of America? Michael wants to know, how come the boy who wasn't fit for your daughter is the father of the brightest grandchild in the whole world? And Bill said he got a disease that is so rare, they haven't even named a telethon after it. And you hear what the senior citizen said? She said, if I'd known I was going to live this long, I would have taken better care of myself. The Continental Hofstadter DeLorme file is up to, here's a volume page, I just threw it in the chair, it's volume 18. Here's a new file that had to be started, volume 19, starting with page 3000. And in the mail comes this Appellee's brief written by Walsh too, and it is an exact copy of his argument for summary judgment. He took this out of the district court and copied it and put it in the United States Court of Appeals. I just don't know how a lawyer can write papers like that. And I've said before that I suspect they are under some kind of an influence of some kind of a substance influence, because I don't think that uninfluenced substance people would write papers like this. And so where did 8 hours go yesterday? 8 hours yesterday went into refuting this mess that I just showed you, his Appellee's brief. And here are the first 10 pages. You know, I only have 25 pages in an appellant's reply brief, and 21 of them are used up already. So I've just got to tell them, the United States Court of Appeals, that there is nothing new in this brief by the appellees, Hofstadter et al., and that I have already refuted everything in this brief by opposing his motion for summary judgment. So I've just got to tell him in 2 or 3 paragraphs that that's the way it stands, and that this is really a hoax on the court. I really suspect there might be something going on. I think there might be outside pressure on this case. The fact that on to Parker and on to Smith, that this case has taken 46 weeks, that discovery has been stayed, and that a motion for summary judgment has been allowed, and that Parker, all the way up to deciding in favor of the preliminary injunction, all of a sudden turns around and denies it. There's something very clear going on in this case, because Glendora versus Malone, Magnus, and TCI, which started 8 months later, is way ahead of this case. Discovery's just about over, just about ready to set the trial date. Something very peculiar is going on in this case, and I suspect it's outside influence. And here's his, and Walsh has written the same thing 7 times. He writes and repeats the same thing 7 times. Here is their book of exhibits, and those have been submitted now 9 times. Same ones over and over again. Let's see what else. This much more I have to 21 to 38, and it's all repetition, 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 repetition. And I don't think that it's done in a person's right mind. I think it's done by a computer. I think Walsh is a hack. They have no defense. They never will have any defense. They filed no Rule 9 statement, as they're required to by the local rules. The court hasn't done anything about that. They are traitors, as I've told you, to their country. He doesn't counter any of Glendora's points in her appellant's brief. And why are they so afraid to go before a jury? See, that's the public's theory. Because they know what you think of them. And they're scared stiff and deaf to go before a jury, where I'm asking for $298 million damages for violation, reckless violation of my statute, constitutional rights, and of the other 38 programmers they robbed. I have something nice to tell you about Melissa Cooper. She's going to give me a special, and it should be this program right here. She's going to give me a special on July the 29th, a Monday, at 8:30 p.m. on Channel 19 South. And as I say, next week, I will read you from pages 81 to 90. And this appellant's brief, reply brief that I'm writing now has to be in Monday. I think another 6 hours will finish it. Or it will finish me. Okay. Now, let's tell you some jokes. To have you anything left? And Gloria said that the food in the hospital was so bad, she asked the doctor if she could go back on intravenous feeding. And the hotel clerk said to the guest, "Do you want a room with a tub or a shower?" And the traveler says, "What's the difference?" And the hotel clerk said, "Well, with the tub, you get a chance to sit down." Glendora versus Hofstadter, traitor to America. Hofstadter, Delorum, and Schleier. Remember, Mark 15:12, for we all must stand judgment before God. everybody to about the 82nd, 3rd, or 4th chapter of the law breaking of John C. Malone, Bob Magnus, TCI, which is Telecommunications Incorporated, the most evil, the largest, and the crookedest cable TV operator we have in the United States today, and the most monopolistic. We will report to you on their law-breaking, lying, and covering up for the week from July 18th to today, Thursday, July the 15th. First up, jokes. Hazel says, my boyfriend and I have a strange and wonderful relationship. He's strange and I'm wonderful. And Harvey says that he's very active in church, and his mother-in-law says, yes, what that means is that he wiggles, squirms, and fidgets. And Hank says that he just came back from a pleasure trip, and Herb says, what was that? And Hank says, I just took my mother-in-law to the airport. Now, first up, Friday was Long Island all day. Saturday was writing the Fox letter briefs. Letter briefs 100 to 114. Glendora versus Malone. These were written on Saturday, and I believe finished on Sunday, and then the Silverman paper was written. But this conference was set up at July 15th, 96, Monday at 4:30 p.m. It was to be about Glendora. Never had a chance to say anything. July the 12th, 1996, Friday, from 1:35 to 2 p.m. about informal papyrus objections and her written objections to the same submitted on July 15, 1996, 83, 8:30A. Well, now that is a conference that you know all about and you heard on audio tape. This is letter brief 100, and it was the conference with Mr. Schimmel, Ben Wiles, and Glendora. So, okay. And you know about the dub. You know all about that. That was last week, how the sealed record was on the dub that the court issued to me, and it shouldn't have been. And so when I got up to that point, I fast-forwarded it and went through it without hearing it. Remember, I told you all that. Okay, that was about letter brief 102. This is letter brief 103. And this is Franklin's report on the Judge Fox conference, June the 16th. And you've heard all of the audio tape of that conference on June the 15th. That's letter brief 109. Ben Wiles is still lying about the public access file. They're still covering up. They're afraid for me to come and do the inspection, and I'm allowed to do inspection by law. And so they're going to produce all the papers, and that's the last thing I want, is all of their phony papers that don't give you the papers, the truth that you should know. Judge Fox reminded Ben Wiles he's an officer of the court. Oh, this is kind of interesting. The 15 worst discovery failures of this case. Glendora got gypped out of her interrogatories, no home addresses. Barry Marshall was protected from being deposed. Franklin Buell was unnecessarily deposed. Admissions left unanswered 30 days were not deemed admitted. Rule 36. No inspection, no insurance policy produced. No proof of must carry WRNN and WMBC. Frenetics and hysterics over armed and dangerous. No audit produced by the Public Service Commission. Public access costs do not include $200,000 worth of video cameras, lights, edit controller at all. Ben Wiles wrote all the statements and defendants perfunctorily signed them. Defendants did not write their own statements. Ben Wiles interviewed all defendants and set the scenario, what lies each should tell when they were deposed what happened and what was said at the meetings. TCI and municipalities was whited out. Temper fits from the bench, shouting, rudeness, judicial conduct. A judge should be patient, courteous, and dignified to litigants. Audio taping depositions pursuant to Rule 30B2 and saving saving an IFP $2,200 May the 16th, May the 17th, and May the 24th. So then every one of us shall give account of himself to God. Point 3. I included what Judge Silverman said in my victory decision that put me back on TV and Cablevision because they were breaking the law by keeping me off the TV. I say that Judge Fox must know a lot about television. Doesn't he own Fox Broadcasting and Fox Channel 5? Wiles is showing more and more desperation, frenetically poking around for a defense. The IFP, looking into my IFP and trying to get it. IFP is poor person relief, informa pauperis. That's real desperation on his part. Judge Fox said to him, "Why don't you concentrate on the merits? You've got a case to defend." Who was the attractive woman with Ben Wiles in the ante-room, United States Court of Appeals, room 1701, July 15, 1996 at 10:45 a.m. Conferences on Tuesday are bitter. That's the night at Glendora. Used to be on Channel 8, 9 to 9:30 p.m. before Malone Magnus to TCI at all. Wiles murdered public access and have been carrying and covering up ever since.